to discuss. I did a comparison, so forgive me in advance
Do the comparison.
with a couple of rules.
Oh, yeah.
And
Guys, if you wanna, we're ready to go live, so whenever you guys are ready.
are we ready?
Yeah.
Okay. So how do we begin?
I think you call the meeting to order. Yeah, here, that brings up,
Who does that?
well, that brings up another point. You're the neutral,
Right.
presumptive chair. We probably ought to take a motion
I think we need to do
to
that.
nominate you as the chair and vote on it. Or to nominate a chair.
Is that a rule?
I don't think so,
I don't think so either.
but I think it's just procedural.
No, that the neutral is the chair. Is that?
No.
I mean, I've seen
it's-
all kinds of
I agree.
combinations.
That's why I think we need to
Yeah.
take an action to identify a chair.
Okay. I'd like to know the responsibilities first.
Well, just really to run the meeting. I mean, I don't think.
Okay. Okay, well, let's come to order. And how about if we start by introducing ourselves?
Sounds like a plan. My name is Vince Yermal, representative of the president here on the Santa Fe Community College Labor Management Relations Board.
I'm Justin Kaufman, and I am the labor representative for this board.
And I'm Marlene Choyer, and I am the neutral on this board. So this meeting is our organizing meeting, correct? And shall we also introduce the other folks who are in the room? Mr. Kennedy?
I'm John Kennedy. I'm of counsel with the Cuddy McCarthy Law Firm, and I am here as counsel to the board itself.
Okay. And we have a large audience today. Would you like to introduce yourselves?
Yes, I'm Jamie Turris. I'm the Executive Director of Human Resources and Professional Development for Santa Fe Community College.
And my name is Keith Beard. I'm with Sutton Fair and Brown, and I represent the college in the labor relations matters before this board.
Okay. And our tech folks are,
I'm Donna Wells, and I'm the Executive Assistant to the Governing Board for the Community College, and I'm also assisting you guys.
thank you.
And I'm Marshall. I'm your AV support.
Thank you. And we have a gentleman who's just signing in. We're just doing introductions.
Steve Martinez. I'm a history professor here at Santa Fe Community College.
Okay, welcome, and thank you. So, we don't have a prepared agenda for our meeting today, shall we? Yes, we do, sorry. Thank you. Okay, first agenda item is determination of quorum and call to order. According to the rules that we have not yet adopted, a quorum equals all three of us. And all three of us are here. Adoption of agenda, public comments, action items, non-consent, promulgation of labor management relation rules, and adjournment. So, can I hear a motion to adopt our agenda?
I move to adopt the agenda. I don't know that this needs to be an agenda item, but I think it would be appropriate for us as a board to identify a chair. And to that end, I don't know if I'm jumping the gun, but to that end, I nominate Marlene Choyer.
How about if we get through the agenda first? Shall we do that? And then move on to chair?
Whatever works for you.
Do we have a second for adoption of the agenda?
I'll second that motion.
And all in favor?
Aye.
Okay. So I should have stated, with the addition of identification of a chair, the agenda has been adopted. Shall we move on to identification of a chair?
That sounds good.
Okay.
Yeah,
Once
may
again,
I interject Ms. Schwarley,
Please.
you don't have appointment of officers on your agenda, so simply appointing somebody to chair this meeting is, I think, appropriate to conduct the meeting, but you probably need to have an action item on your next agenda to actually appoint officers for the board.
I'm way more comfortable with that than jumping there right now.
Simply a point of clarification.
Okay. Okay, so to clarify, we're identifying a chair for the purpose of chairing this meeting. And nomination?
I nominate you, Marlene Chouaye.
Thank you, I think, Vince.
I'll second that motion.
Thank you. And being clear that that's for purpose of conducting this meeting and that we will include organization of or election of officers at our next meeting. So all in favor?
Aye.
Aye.
Aye. Thank you. Okay, moving right along. I hope all of our meetings are this fluid. Public comments. Are there any comments from our audience?
If I may, Madam Chairman, my interest here is to ensure that the best interest of all faculty members at this college are looked after and not part of the faculty that make up this community college. So that is my purpose to be here. Again, I think it's very important that we as faculty members participate in these types of events and that our voice be made clear. And so I'm a little disappointed that other faculty are not here, but I am here for that purpose.
Could you clarify a little bit more your concern, your differentiation between all faculty and not
I
just
think
some?
we have a divided campus right now in terms of faculty, in terms of faculty that support the union, and faculty who are really still trying to decide for themselves. And I think that there is a unheard voice for many faculty that has not been represented. And so my purpose is to sit here this morning for a few moments, because I have a class, unfortunately, to let you know that I think that we have a wide range of views currently at Santa Fe Community College, and that it is all not centered in support of AAUP. There are many faculty who are still trying to determine the role that they want to play as faculty members and whether or not AAUP is the best voice for them. And so I wanted to make sure that that was made perfectly clear.
So thank you for your comments. Is it appropriate for us to engage in some discussion?
Madam Chair, it's typically my advice to public entities that you not engage in dialogue or discussion of public comment matters because they're not agenda items, and it could be walking you into an open meetings violation.
Appreciate that. Thank you.
Thank you.
Any other comments?
No, no one else signed up for comments.
Okay, let's move on then to item 4, action items, non-consent. The only item to be considered is promulgation of labor management relations rules. And I think that we have some questions for council in that regard. Vince?
Well, again, John, a procedural question in terms of we will review these rules that have been put forth, discuss questions, hopefully resolve what we would at least like to see as the final product of this. But do these rules then need to be published and acted on in a subsequent meeting?
Well, they're on the agenda for adoption at this meeting,
Right.
but since this is your organizational meeting and perhaps you haven't had a full opportunity to analyze them and suggest revisions or have a dialogue among your fellow board members about the rules, these are the governing rules for how you do your business. There are basically 3 things that the local labor board does. You handle petitions for representation of individual bargaining units, you handle prohibited practices complaints, and you adopt rules. The rules here are fairly similar to what the state Labor Board uses as their organizational rules or procedural rules for doing those three things. Since this is your organizational meeting, if you wish more time to analyze them, you wish to have more opportunity to discuss them with your fellow board members after a more thorough review, you can defer them to another meeting. So it isn't required that you adopt them today.
But we could.
Oh, you could, yes. They're on the agenda for action if you choose to take it.
Fair enough.
Okay, so how about if we begin our discussion of the rules, if that's agreeable to everybody, and let's see how far we get, and if we can, if we're in a position where we can amend or adopt as is, amend and adopt, or if we find that we need more time, then we can make that decision as well. So, could we have a little history on the rules? I noticed I was looking at a couple of sets of rules from a couple of labor boards. There are some significant differences in the rules. Do we know how this set of rules was generated?
I do not. I would defer that to Mr. Meir, who represents the university, and I think his firm assisted in drafting these rules for your review.
Sure, board members, thank you. So my understanding is these rules came from the Community College Council as kind of a survey of other rules of labor management relations boards, in particular community colleges. And so they were sent as kind of a recommendation to you all as here's a template, here's some rules that we see around New Mexico for these local boards and community colleges in particular. And so they were just meant as a template for you all to discuss and hopefully set you up for success in adopting rules that make sense for the board.
Okay, thank you. We certainly need a starting place. So do you know when that was done, Mr. Meir?
Ma'am, I don't have an exact date. I don't know. I know it was emailed, I think, to the management representative to kind of send out to the rest of you. I don't have a date, though.
Okay. So we wouldn't know then if there have been any rule changes by the PERB since these rules were compiled?
There have not been any rule changes by the Public Employee Labor Relations Board. I can assure you of that. There are some that are pending, but these rules comport with the rules that comport with the resolution. As far as the PELRB goes, the resolution that you all are operating under has been approved by the state. It's the current version that's allowed by the state, and these rules, again, are those that other institutions are using. And again, they flow from the state board rules.
Okay. Okay, so do my colleagues have any suggestions for how to proceed with reviewing the rules? You want to take it one by one?
Sure.
Okay. Okay, I will share that I did compare these rules to just a couple of somewhat random selections. I couldn't find any rules for any other community colleges. I imagine that they're available, but they weren't accessible online. But I did find the rules of UNM, Labor Management Relations Board, and Doña Ana County Labor Management Relations Board. So that's my basis of comparison. I wonder if anybody has looked at any other rules?
I have not, no.
Okay.
I have not, other than that several years ago, I had an opportunity to review those at CNM,
That's what I was looking for.
and these are very similar.
Pretty consistent?
Yeah.
Okay. Okay, so I do have questions. First of all, the general provisions, I had no questions. Does anybody suggest any changes?
No.
Okay, that's 1.1, general provisions, so we're okay with that. 1.2, definitions. Any changes, suggestions?
Not on my part.
Nope.
Okay. 1.3, computation of time. One thing that's not specified under computation of time in these rules is, are days considered calendar or business days? And I think that that's something that would be helpful to specify in this section. Your thoughts?
I mean, I guess the way I understood it, it's calendar days because it does specify what happens if you're on a Saturday or Sunday. So I think it's probably speaking to just calendar days. But we can make it more clear for sure.
Well, I draw a somewhat different conclusion in that my reading of it is that in effect, this excludes Saturdays, Sundays, and legal holidays,
Right.
which suggests that they are business days. But the point, Justin, is not to take issue with that.
Yeah.
As much as it apparently, we're drawing obviously different
Different.
conclusions.
Yes.
And I think Marlene's point to clarify that is well taken.
Yeah.
So, looking through the rules and the time limits, I think if we're looking at business days, that some of the time limits are really extensive. So I think my preference would be that we count by calendar rather than by business days or working days.
Right.
Is that agreeable?
That's agreeable to me. I just think we need to insert language into 1.3 that makes that clear.
Suggestions for language? Unless indicated otherwise.
Yeah, may I? interject?
Please.
Please, John.
I think that in context, that the first sentence of paragraph 1.3 is talking about calendar days, because thereafter it exempts Saturdays, Sundays, and holidays from any deadline. And the last sentence actually refers to business days and says when the last day of the period falls on a Saturday, Sunday, or legal holiday, then last day for taking the action shall be the following business day. So I believe the context of the paragraph is talking about calendar days. So, and
Would it be-
this is the way in which the State Labor Board conducts their business. They typically exclude the Saturdays, Sundays, and holidays when they are imposing a deadline, and I think their rules say that if there's a deadline that's less than 10 days, 10 calendar days, it's business days.
So would there be any downside to adding a sentence to clarify?
Well, I think it's easily done if I may suggest, simply adding a specific number of calendar days in the first line.
Easy.
A specific number, yeah. Just insert the word calendar in that first sentence.
Okay, we're all,
Sorry for interjecting.
Not at all.
we appreciate it. Thank you. So we're all good with inserting language. So the first line would read, when these rules state a specific number of calendar days in which some action must or may be taken after a given event.
Okay.
Yeah, Justin? You
Yes,
good?
that's fine.
Okay. Extension of time. We're okay. I didn't see any issues with that. Okay, filing with the board, later on, that's 1.5. Okay, later in the language, and I can't remember which section, but we'll get there eventually, there is a specific date of action or a specific time frame within which action needs to be taken. I think it's 6 months for a prohibited practice complaint to be filed. I wonder if it might make sense to take a look, A, at including that timeline in this section, which is something that Doña Ana has done, and B, when we get there, is 6 months an appropriate length of time. Or Doña Ana, for example, states that prohibited practice charges shall be filed with the board within 90 calendar days of the commission or omission. I think we have to take care when we're making these kinds of changes, but what are your thoughts?
Well,
Mr. Yermerl, if you're looking for the deadline, she's talking about the section 3.2 on page 21.
Thank you.
Didn't mean to presume.
Thank you. Limitations period.
3.2 on what page?
21. Do you have a page 21?
Nope.
You know,
But I might have a
3.2.
3.2.
yeah, the page numbering was a little bit funky. There were a couple of blank pages, so
Yeah, mine.
it might be
Mine are
different in
numbered
different
oddly
versions.
because mine reads page 21 of 20.
22, right, yeah.
So I don't know which version I'm working from, but it's section 3.2. The last
I got it.
series is the prohibited practices procedures.
You got that?
Yep.
So let's jump there. Any complaint filed more than 6 months following the conduct claimed to violate the resolution, or more than 6 months after the complainant either discovered or reasonably should have discovered the conduct shall be dismissed. That seems to me to be a pretty long period of time.
I agree.
On the other hand, I certainly don't want to reduce the rights of employees. So if we were to change that time limit, would that be a burdensome for a potential complainant?
My feeling is to leave it at 6 months. I don't think it should be any shorter. It sounds like that's, that to me seems to be the sort of generally accepted time period for filing a complaint like that. So I think on that issue, I'd prefer to keep it like that.
And that is the time limit that's in the State Labor Board rules,
Yeah,
6
yeah.
months. So it'd be consistent with that.
Yeah.
My only concern is that the 6 months is contingent upon either the discovery or reasonable expectation of discovery. So arguably, the 6 months could turn into a year or into 9 months. And that does seem excessive. I mean, I don't have any objection to leaving it at 6 months per se, although I think there is I think you have merit to your comments about the 90 days as well. I think it's important to move these issues along.
I think it's in everybody's interest to have a prompt process, as prompt as possible. But again, on the other hand, would 90 days be, or somewhat shortened, be unreasonable, Justin? Given Vince's concern that, reasonable discovery could say, on day 179, I realized something.
Well, I think I feel pretty strongly that the reasonably discovered language should remain in.
Mm-hmm. Oh, yeah.
And so, I have to say, with not a lot of experience seeing these types of complaints, it's hard for me to imagine what kinds of things might occur that would cause the delay, that would cause a complainant to, take 6 months to file something. But I know, I'm concerned at making it shorter than, what the state labor board might use, or what other boards like this might use. But I do feel strongly that they're reasonably discovered. I think in most instances it'll be pretty straightforward, and that won't be an issue.
I would agree with you. And that's the thing I'm turning my thinking on, is the reasonable discovery.
Yeah.
I'm having trouble imagining what would take 6 months, once you're aware.
Right.
What would take 6 months to file the charge.
I agree with that, and then so we're drawing the line at 6 months, and it shouldn't be any longer. It shouldn't be any longer than that, but that seems like the right time period. I think 90 days might be too short, but again, I haven't seen enough of these to know what might take someone 90 days or 95 days or 120 days to put something together.
Well, we have the Doniana, or Marlene at least, identified the Doniana ordinance with a 90-day rule.
Right.
You got the state at 6 months. What was the other one you said you had, Marlene?
UNM is 6 months.
6 months?
Mm-hmm.
Yeah. So I think there's ample precedent to the 6 months.
Okay.
Okay, I'm okay with that. Shall we add language in this section that, it would be redundant, but I think that somebody might reasonably look at section 1.5 and have a question about timelines?
My only concern, Marlene, for what it's worth, is that the only other filing referenced in here with the board? And if you call that one out specifically, do the others then need to be called out specifically?
Good point. Mm-hmm.
And I think the rules have to be considered in their totality.
Yeah, I
point.
agree with you, Vin. I think 1.5 shouldn't call out any specific time frame. It's more of it's a broader provision that tells you how to file whenever you have to file. The thing that the comment that I have with 1.5 is it doesn't look like we've spelled out, we know who the board is. We need to have some central repository where things get filed so that they get to us, and I don't know how that is typically handled.
And that could also be specified
Yes.
in this, and I think actually, thank you for that, I think that's also in both of the rules that I reviewed.
Whether it's
There's there's a specific address in one of the rules. So, excellent question. So, to whom would complaint be sent? Would that be to Ms. Wells, our administrative support person?
Can I make a suggestion?
Please.
It's up to the board to designate a place, a repository for filings. Since you are the Santa Fe Community College's local labor board, I think that the administration could set up a Dropbox for you or an address for you to use so that it would be known and published by this board that that is the repository for communicating with this board. So that even if it's just a letter to you rather than an official filing, there's a place where you can be reached by either a physical, a post office box, an email address, whatever, so that there is an identity separate from the college for this Labor Management Relations Board.
Yeah.
And I don't know how we would do that structurally, but I think that's something, a task that this board could make a request to the administration to take care of.
John, I think that's an excellent idea. However, I also think that a position or some person, position, department within the structure of the administration needs to be identified, lest we have our chair stopping by here to check the mail every day, which I don't think makes sense.
Administratively, I think that should be addressed as well,
Yeah.
so that somebody monitors that box. But, you know, setting up a structure so that you can be the recipient of appropriate filings and communications from either the public or from people within the college community.
Right.
And you know, because there are so many modes of communication these days, I think there simply needs to be a little index card saying who you are, how you are reached, and who is responsible for assuring that if something comes in, it gets to you.
So, John, could you help us out with the mechanics of it a little bit? So, should there be an email address to which each of us would have access,
Well,
in addition to a physical location?
Well, that's a possibility on certain types of communication, but on formal filings with the board, I
to be
think
by
they
mail
need
or
to be
fax.
hard copy
Right.
and in the possession of somebody
Agreed.
in the administration.
Correct.
Agreed.
I think the email idea is kind of another layer of communication that is good for informational. By the same token, the community college has each of our individual emails and can communicate with us collectively. So I don't know. I don't know how, for example, I mean, I know technically you can. I don't know that I want to have to access a separate
No.
email somewhere.
So, hard copies, the rules are clear about fax transmission has to always be followed by a hard copy, so we definitely need a hard copy point person and location, and then we can talk about the email address if somebody just has a general inquiry or something of that nature. So could we request that Ms. Wells help us with that and find,
A mechanism?
yeah.
Are there mailboxes
You're the mechanism.
here?
Let me check with, on my end and see if there can be like a physical box that's locked and that people can, put suggestions or comments or filings that I could check once a day. Is that what you're thinking of?
Well, I'm just thinking out loud, so
Okay.
excuse me, but I know at the city of Albuquerque, if you were going to file a grievance, or depending on the contract, of course, we had 7, but if you're going to file a grievance or a prohibited practice complaint with the board and so forth, it had to be served to certain specific individuals, all right? Whether it be the chief administrative officer or the human resources department, the city attorney kind of thing. And so I think it's a matter of, and again, just thinking out loud, I think it's a matter of determining that documentation is served to the executive assistant to the board, the executive director of human resources. I don't know that it necessarily matters who, but just somebody be identified as essentially the custodian of that stuff, that then needs to be communicated to us.
Dan, do you, as the Executive Director of Human Resources, do you have any suggestions about, or Keith, in terms of receiving a formal process for receiving filings and where they should live and?
Well, our current president's preference is that all those type of items go directly through the president's office. At least currently, anything that we're served legally goes to the president's office before it comes to human resources. Because inevitably our mail distribution has had some issues, so on occasion, human resources didn't get that served directly. So I think there's pros and cons to either way. So if it came directly to human resources, that would be okay, but it would kind of be inconsistent with how we're handling other ones.
And if I could interject, I would suggest you stay consistent.
This is just a suggestion. My recommendation would be that it comes to the executive assistant. That way, I mean, given the nature of what you guys are going to be asked to decide with respect to prohibited practices, I think it makes a little more sense that it's filed with your executive assistant. That way, you know, there's a stamp and it goes to, you know, everybody knows that it's there. Management, there's no concern that management's had a look at it before labor does. That would be my recommendation. I think it makes a little more sense that way. You know, there's no confusion about who's received or seen the document.
Donna, if a piece of mail were to be addressed to the Santa Fe Community College Labor Relations Board, care of Donna Wells, it gets put in if you can create a box that receives that gets stamped every day when something's received, and then the procedure is it gets stamped and it's scanned and emailed to the three of us. I think, you know, that's and so that way the rules are going to say under 1.5 to file a document with the board, a filing is complete when it's mailed or hand delivered to the Santa Fe Community College Labor Relations Board, care of Donna Wells, you know, executive assistant, and this address, you know, and that way that's the one place where things get delivered and filed, and it's official once it's delivered there. But we have to make sure that works in your office and that can be set up.
And I would suggest we use a job title as opposed to a proper name.
I agree.
Yeah.
Yeah.
That's true. That's a good point.
And if I may, board, excuse me again for making a recommendation from the cheap seats, but I would also recommend, given that you have board counsel, that maybe board counsel is including on those filings for time limits and stuff, so that you have somebody that's tracking that for you. I know you all have other things going on, and that's the purpose of the college.
Yes, for sure.
Okay.
Yeah, so there's sort of a standing rule in your office that every day it's checked, stamped, and emailed to the four of us, and then we can kind of keep track of what goes through that box.
Okay.
So we'll need, in addition to the physical address, also a fax number.
Okay.
And we're in agreement that we want to include that information in section 1.5.
I think
Correct?
so, yeah.
Okay.
Do you want, excuse me, Madam Chair, do you want it in your rules, or do you want to simply have a central location designated? Because if you then change it, you've got to change your rules. It's a rule-making procedure. So I would think that the rules say you can designate who takes care of this, and you're going to be publishing minutes, you're going to be posting notices of things, and it may be wise to simply have that designation included in your minutes or included in whatever posts there are. I assume there may be someplace on the community college website where information about this board will be accessible, and you could include it in there. So that I think simplifies it, because then you're not going to use Donna's name, but you're going to use her official function. But if the address changes or whatever may happen, you have a designation someplace else that can be more easily adapted. Does that make sense to you?
Yes.
Okay.
That makes a lot of sense. Thank you again. Which leads to a question about how we publish or how we make our information available to concerned parties. Will there be a link, for example, as there is for the governing council, would there be a link on the website? Would we have a page that could be accessed?
I think so. Todd Lovato, who is the executive director of marketing and public relations, will create a page specifically for the Labor Management Relations Board. We are taping the meeting, and the link will be posted on that page, and any information about activities or anything else that you want the public to be aware of, we can put on that page. So
So will Mr. Lovato maybe we can ask him to join us at a meeting, and we can talk with him a little bit about what we would like to
Sure.
see once we have a better idea of what we'd like
Yeah,
to see.
he's at the executive team meeting right now, but yes, we can certainly ask him to come and talk to him about what you would like.
You have a list for a following meeting.
Right.
Already.
Okay. Okay.
Go back to 1.5. The language is okay.
Yeah,
As is, yeah. Okay. 1.6, representation of a party. I did not see any changes in that.
I'm fine with it.
Okay. 1.7, I think there was a typo in the, I'm sorry, I'm born with a red pen in my hand, I think. A typo in the last line, I think, should read, it shall not be a violation of this rule for a party to communicate with anyone concerning any rulemaking proceeding of the board, or to communicate with a mediator, arbitrator, or board member at the mediator's, arbitrator's, or board member's request. I think that's simply a typo.
Right.
Okay.
Subject to that change, it's fine with me.
Yep, me too.
Okay. 1.8, disqualification. We're good?
Yep.
1.9, motion to disqualify. Okay, 1.10, records of proceedings. Let's see, had some references here and I don't know why. Let's see. Okay, UNM included, according to transition. Oh, okay, language in UNM that I wondered if we might want to consider. Additional sentence at the end of the paragraph. Any party to a unit determination, prohibited practice, or other adjudicatory proceeding may, in the absence of an order of the board, arrange privately for certified transcriptions of the proceeding at that party's own expense. That party shall send a copy of the transcript to the board and shall make the transcript available for review by the other party to the proceeding. The board may order that such transcript be the official record of the proceeding. That's in UNM, so we might want to consider that. And in Doña Ana, the board's recording or transcript shall be the only official record of a hearing and shall be maintained for 3 years after the hearing is concluded. I don't think there are any. In 110, it says 1 year. And it also says that the audio tape of the meeting may be erased for regular meeting, not for a hearing.
It doesn't say that the audio tape may be erased? Is that what you're saying?
It does in our 1.10.
Right.
In Doña Ana, it does not. And Doña Ana also has language, the board authorizes its staff liaison appointed by the county on its behalf to schedule hearings and meetings, draft agenda, publish notices, issue subpoenas, and otherwise perform clerical matters on behalf of the board. Is that necessary language? Okay.
So there's really two issues that I've heard you raise. One is 3 versus 1 year, right? And the other is parties to the complaint or whatever can essentially hire their own court recorder. And then at their expense, and that becomes the official record,
If the board
if the board
requests
accepts
so.
it. Yeah.
Right.
So,
I wouldn't opt to increase the length of time for which we have to hold on to recording.
I agree.
Okay.
agreed.
What about the permission of another party to create a transcription that may become the official transcription? I don't know, does that open something up that we don't want to open up?
Well, it's not uncommon in proceedings in which there is no arrangement currently made for a court reporter to prepare a record for one of the parties to request. If I may make a suggestion, the last sentence of this paragraph says, "The board's recording or transcript shall be the only official record of a hearing unless otherwise designated by the board."
Do you think, John, given that, do you think it would be worthwhile to put in the additional language that if one of the parties at their own expense chooses to do that and subject to the board's acceptance of that transcript? I think those are all useful.
You certainly can provide that option, and adding it to the rules is absolutely acceptable if you wish to clarify it in that way. It isn't uncommon for it to happen even if it's not written in the rules.
I don't see any.
So I was simply trying to
Yeah,
streamline a little bit if you
understood,
choose.
understood.
If you want the additional detail, that's
sorry, I
that's
didn't-
your discretion.
I don't think it's a problem to add it. I mean, it might make sense just to add it to the rules.
It's crystal clear then.
Mm-hmm.
And your thoughts, Marlene, in terms of adding that sentence?
I would add it and include your language, Vince, with permission of the board, because that's not in the UNM language. So it would read, with the consent of the board, any party to a unit determination, prohibited practice, or other adjudicatory proceeding may, in the absence of an order of the board, arrange privately for certified transcription of the proceeding at that party's own expense. Why would we need the language in the absence of an order of the board?
I don't think we do. But let me raise this question.
Mhm.
All right, at the consent of the board, well, how do we consent?
Right.
Do we need to have a meeting?
And we'd have to have notification, they need to notify us a particular amount of
Yeah.
time ahead,
Yeah.
that can get,
Yeah, I don't think that's necessary either. It seemed like the language that you read without the order of the board. I mean, if someone shows up with their own court reporter and has agreed to pay for it, we're going to let that happen, and that's going to happen. And it sounds like the way John's explaining it, that often happens without us even putting this in the rule, but
Well, and where we consent is whether or not we accept their version.
as the
So to speak,
official.
as the official.
Yeah. We're already being recorded anyway, so it's
Exactly.
not I don't think it's a big deal.
okay, so we're in agreement. Let me read the language again, then make sure we are clear. Okay, so what we are proposing adding to Rule 110 is, any party to a unit determination, prohibited practice, or other adjudicatory proceeding may arrange privately for certified transcription of the proceedings at that party's own expense. That party shall send a copy of the transcript to the board and shall make the transcript available for review by the other party to the proceeding. The board may order that such transcripts be the official record of the proceeding.
That's fine.
Okay. Okay. 111, notice of hearing. There was a slight change in the UNM language. No, our language says, notice may also be served by fax transmission provided an original is deposited in the mail no later than the first workday after the fax is sent, in which day the date of the fax transmission shall be the date of service. Oh, never mind, sorry. No, they just changed the syntax a little bit, but there was really no change in the content. So paragraph A looks okay? Okay. Paragraph B, why would we want or need a newspaper of general circulation in Albuquerque? I think we might want to change that to Santa Fe.
I want it to be Santa Fe.
Okay. Any other changes under notice of hearing?
Nope.
Okay. Evidence admissible. Okay, this was interesting. Section A in Doña Ana was completely different. Well, okay, no, not completely different. Doña Ana added, the board shall be the final authority concerning admission of evidence. Let me read theirs in full. The board shall be the final authority concerning admission of evidence. The technical rules of evidence shall not apply, but evidence of a type commonly relied upon by reasonable, prudent persons in the conduct of their serious affairs shall be admissible at hearings.
If I may, Madam Chair, the paragraph A, as it stands, is a fairly standard statement of admissibility of evidence in an administrative proceeding. The technical rules of evidence don't apply to you, but you can require reasonable substantiation of any statements made or documents presented. That's almost boilerplate. Mm-hmm. So I think it's sufficient as it stands if you're satisfied with it. It isn't there isn't really any great dispute about that, and when you're in hearings, I have observed administrative board members being fairly diligent about making sure that whatever is presented is reliable evidence.
I would be reluctant to incorporate words such as reasonable, prudent, and conduct of serious affairs. Okay, so that was interesting.
If I may, I think that says the same thing as this, only it says it in a way in which somebody had a beef with this language and decided to clarify it.
Needed to put their
I
thumbprint
may
on
speculate.
it, right? Okay. So
That was a speculative statement, and it would not be admitted in evidence.
do we need to add, the board shall be the final authority concerning admission of evidence?
I don't think you do, because you are.
Okay. Okay. Anything else under evidence admissible that we need to take a look at?
I don't think so.
I don't think so.
Okay. 113, misconduct. We get to eject rowdies. Can't imagine that that's likely to happen.
You haven't dealt with some of the people that I have.
I have had partners in my law firm break up fistfights among board members in public meetings. So disruptive conduct happens, but we hope that it will not happen with any meetings that you're having.
So is that part of your job in case any of us?
Sounds like we need that
Honestly,
paragraph.
the partner had to
Leave that one in.
referee. So
Okay, subpoenas. I wondered if we needed to include timeframes for subpoenas here. I think that is something that's in Doña Ana. I think a subpoena request shall state the name of the case and be submitted to the board no later than 5 working days before the hearing. Would that be a good idea?
yes.
And is 5 working days a reasonable amount of time?
Yeah.
Okay. Okay. Do we need to include in the last line, otherwise the board or its agent shall immediately issue a subpoena? Would that be a good idea? Okay.
Where was that, Marlene? I'm sorry.
That would be
Last line.
A, last line, otherwise the board or its agent.
If I may, Madam Chair, if you're adding a 5-day ahead of the hearing time for requesting a subpoena, I would put in notice that the opposing party received notice that a subpoena is being requested in case they wish to quash it before a hearing. So notice to the opposing party of a request for.
Is that under the quash language?
It isn't now.
It just says you can quash it.
You can quash,
What I'm
okay.
saying is give them
Got it.
time to-
Yeah, the motion to quash has to be filed with the board, but if you don't know that there's a request made, you can't seek to quash it.
Should that notice statement go in under C,
I would put it in A.
A?
Yeah, because it should be a notice when the request is made rather than when the subpoena is actually issued and served. I mean, again, it's up to you, but I think mechanically it gives parties at least an option if there's a dispute. And that is a process that I've observed in other administrative subpoena structures.
Okay. So we'll include that under A. B, yes.
Can I just ask a quick
Please.
question? So we are giving, so a party who wants to issue a subpoena gives notice to the other party that they're requesting a subpoena.
Exactly.
The board that then may or may not issue the subpoena, but the context of this is a party asking for a subpoena to get documents or a witness from a third party, not from the other party involved in the case, because the party involved in the case has a different,
They would have to be there.
Provision.
Or they don't need to be subpoenaed.
but there's, the next section talks about exchanging documents and witnesses.
Yeah.
So the party is using a subpoena to get something from a third party, right?
So, yes.
Okay, and then the subpoena would then go to that third party, and that third party may quash it too.
They may
Yeah,
try to.
okay.
Sure.
Okay. So under section C, B is okay, yes? C. Reasonable time after service of the subpoena and if feasible before the hearing. Do we need to be more specific than that? Or is that?
Because your timelines are short,
Mhm.
I don't think you can do more than what this says. I think oftentimes you may show up at a hearing with a motion to quash a subpoena.
Mhm.
And, that's one of the preliminary matters you deal with when you get into a hearing context.
So it says if feasible, it's not a requirement, so it is possible that it could be, at the last minute during the hearing, and that's okay, and we don't need language to permit that.
I think this speaks to how it works as a practical matter.
Okay. Okay. And D, we're okay. 115, any discussion, any changes? 116. 117. 118. 119. 120. 121. I would expect that we could take up at a future meeting what kinds of papers or forms. I would opt for following whatever format the PERB uses. And maybe at a future meeting, we could do some exploration of that and see if we could come up with a stack of forms.
Is 121, 1.21 otherwise okay?
Yeah. I'd like to know what our logo is going to look like, and
Why don't you design one?
okay, 122, I have a note here, closing of cases. Oh, okay. This was the question. Another interesting distinction in Doña Ana that determined that a timeline of 45 working days for taking no action is sufficient to close a case. That seems to be a very brief period of time. Same discussion. Is 6 months too much, just right? You know, when you look at other rules, you start to see trends emerge. But what's our thinking about taking
What's
action?
UNM?
UNM is 6 months.
6 months is what district courts do also, if
Mhm.
you're moving a case along. So I think 6 months is.
It's reasonable. Okay.
I do, yeah.
So we're okay with 122?
We're okay. Okay, 123. Here's the language I have a question about. Our responsibility to classify, index decisions, make tables and indexes of the decisions, as well as compilations of the decisions.
The board or its representative?
Do we want to do or is that required?
May I? I think this is probably what the State Labor Board does, because they do, their decisions are relied upon by other public entities. And I think for your purposes, it may be simpler to simply have a rule that says at the time and in the manner prescribed by the board shall make copies of its decisions, make those decisions available to the public, and provide a record accessible to the public.
I like that.
Does that make sense?
Yeah. And I think for that, we just need to talk to Todd Lovato about getting the decision to him to get it on the website. It probably does it.
You can have a link, decisions of the board.
Yeah.
On the website.
Okay, so with that change,
And could you restate the change, Marlene?
so the language would read, at the times and in the manner prescribed by the board shall make copies of board decisions available to the public and provide a record available to the public. correct?
Yes.
That's sufficient. And maintain records of its decisions available to the public, if I may.
That makes, yeah, that's better.
Maintain a record of its decisions available to the public. Which, as a practical matter, will mean you put a link on your site.
Okay. Time limits for board actions. Any discussion? Okay, 125, quorum. I've seen minutes from other local labor boards where 2 members have been present and decisions have been made. So is that an option, John?
Yes.
It is. So what,
Well, this kind of goes into another area that I wanted to get some guidance on, John. And I think it almost argues for a 3-member quorum. And I would say this. Marlene, do you intend to go to the legal update at the local SHRM chapter?
I do not, for a very specific reason.
Okay, but my point where I'm headed with this is we both belong to that organization. We would likely find ourselves together at that meeting, and if it's only 2, then we constitute a quorum. And so I think the 3-member quorum would allow 2 of us to interact with one another on non-board related matters and not run the risk of creating a quorum. Is my
The only-
interpretation?
Under open meetings.
Legally, you could have a quorum of 2.
Right.
But because of the particular nature of a labor management relations board, and you represent different constituencies, this is not an uncommon rule, but the practical side of it also is you can't have a meeting without all 3 of you present. So it presents some practical timing difficulties, but it also preserves the ability of all 3 members to participate in decisions where it may be a controversial issue. So again, it's up to you. The law doesn't require it to be a quorum of 3. But for a variety of reasons, I think this has been not unusual for labor boards.
John, is my interpretation correct, though, that if it was a quorum of 2, and she and I happen to show up at the same Northern New Mexico Human Resource Association meeting, it's potentially problematic?
Yeah.
Or am I overblowing that?
Well, I deal with that all the time with small boards in small local communities where there's one coffee shop and everybody
Right.
shows up at 5:30 a.m. And my caution to those boards is you can sit at the same table and have coffee, just you can't talk about anything having to do with this board. So you simply have to police yourselves.
And that would.
Does it constitute a quorum? Not officially. Is it something someone could question? Absolutely. People question everything. But it doesn't constitute a violation if you were in the same room and not talking about community college business. You see what I'm saying?
That said, from my own perspective, I like the idea of a 3-member quorum.
Yeah, I mean, I do too. I worry that the absence of one of us is going to stop the work of the board. I wonder is there a way to set up this language that states there's a 3-member quorum except unless the board agrees otherwise, and we agree to go forward with 2 if there's some instance where one of us can't be here. And
But that brings up another
yeah,
good point, Justin, is I'm assuming that, and perhaps I'm incorrect, that if the board had to convene and one of us was out of town, we could call in?
you can. That's the next.
Right.
Okay, so alternatively, the only way we would not have a 3-member quorum is if one of us was, say, entirely unavailable, incapacitated, or what have you. I have particular concerns with a two-member quorum, particularly if it's one of us that's not here,
Right.
because we have a constituency to represent.
Yeah, I think it's fine then. Let's just, the three, I think I'm okay with the 3-member. We just, with enough notice, we just have to make sure we're all here and keep it
And
moving.
if I may, from experience,
Yes.
you know, observing other local labor boards, it hasn't been a problem to get
Yeah.
all 3 members there. And if you're not available, you could call in. You know, if there has to be a meeting within a particular time frame, and you know, you're just. I literally was at a meeting yesterday where a participant called in from Prague,
Right,
but you know, now we have that opportunity.
right.
So.
And we would still need to take the same precautions if two of us were in the same place at the same time under the Open Meetings Act, correct?
Sure.
Or, okay.
Yeah, I mean, it is, you know, if you read the Governmental Conduct Act, being in public office is a position of public trust. Well, you have to treat that as a position of public trust, and you must act accordingly. So, you know, it's not illegal for you to meet at the Human Resources officers meeting or a members meeting, but you know, when you're standing at the coffee, the coffee bar, you talk about coffee.
Right.
You don't talk about the community college.
Okay. 126, any changes?
It sounds like we have the ability to set up a phone in here and
Yes,
call
there is
in.
a phone in here.
Okay.
Okay, Madam Chair? I see we've finished section 1.
Are you going to suggest that we take a few minute break?
Let's
Let's do
take a
that.
very short but deliberate recess.
Let's do that.
This is what I call a pit stop.
Yes, sir.
All right. 10 minutes? 5?
5's enough for me, but we can do 10.
Let's do 10.
Restrooms down at the end of this hall, and then also you go into the cafeteria and kind of around the corner. Yeah.
We are feeling our way along here.
Well, this may be one of the least controversial meetings you ever have.
Understood.
You've had a few.
One or two. Is Cuddy still working with the housing authority down in Albuquerque?
Yeah.
I forget, what,
Garcia,
good guy.
really good.
You guys, just to remind you that it's still rolling.
The record.
Yes,
Okay,
sorry.
that's all right.
It's controlled elsewhere.
So actually, I have to share with you.
We're still recording.
Oh, thank you for that. So maybe we'll make it through, huh?
I'd sure like to. I'd sure like to. I mean, I think it's
Yeah.
feasible. I would suggest we could resume at any time.
Okay,
Onward?
back. Okay, let's pick up with Section 2, Representation Proceedings. I'm sorry, 2.1, Commencement of Case. Any discussion or changes? Two point two, service of petition.
I think it just needs to say upon the filing of a petition with the board. Isn't that how we've defined?
Okay, Vince?
That's fine.
Okay. Two point three, filing of collective bargaining agreement. 2.4, showing of interest. So here is a question, also from Doña County. They referenced stale cards, so that I think their deadline was 270 days. that cards would have to have been signed prior to 270 days.
Would it not be within 270 days?
Correct, sorry. Within 270 days. Do we want to include that kind of language here?
It's an odd number of days, it's an even number, but an odd 270. I mean, what,
Like 9 months?
9
is
months.
that what it-
Yeah. And
Madam Chair.
that number sounds familiar, but I don't know why.
The concern is that on occasion, people will sign a membership card in a collective bargaining unit, and then several years later, there'll be a petition, and the cards are pretty dated. So I think the interest is have active cards. So if you're doing a petition, and somebody hasn't signed a membership card in 5 years, you get them to re-sign to make sure that they are currently interested in having this unit certified.
I think that was a particular issue from the little bit of research that I haven't done on. I don't think that they have been to the bargaining table. And based on some later language, I think that's a particular issue for them. Whether it's likely to be for us or now, might it make sense for us to have language that says something like, no signature that is dated more than 270 calendar days before the filing of the petition shall be counted toward the showing of interest.
Yeah, that's fine.
Yeah, I don't have a problem with that.
Okay, so we will insert that after each signature shall be separately dated. Okay.
Hang on, Marlene.
Yeah.
Trying to catch up here. And what language are you adding
Well,
after that? Each signature shall be separately dated.
no signature that is dated more than 270 calendar days before the filing of the petition shall be counted toward the showing of interest. And then the rest of the language will follow so long as it meets the above requirements.
Okay.
Okay. Section 2.5, information requested of parties. Any changes? 2.6, initial investigation of petition. Any changes?
Madam Chair, in paragraph A, fourth line, it says, the showing of interest has been signed and dated by a sufficient number of employees and that the signatures are sufficiently current. I would put, instead of that, I would put timely as designated or specified above.
Thank you. Any other changes in 2.6?
No.
Okay. 2.7. Two point eight. 2.9, intervention. To 10, consent election. You made it through a whole page. to 11, to 12, to 13, a question. Do we want to add language that says the board may require briefs?
Certainly.
Can we just say if any party or the board requests? Board's not going to ask permission.
Yeah. So we'll add language that says the board may require.
May I
Okay.
suggest
Mhm.
213, first line at the end, it says the board shall permit. Why not put the board may require or shall permit?
Got it.
That work?
Yep.
Yes.
Okay, 214, board reports. Two 15, opportunity to present further showing of interest. Do we want to have a time period?
Yeah, may I go back to 214?
Mhm.
Excuse me for interrupting. Board reports. Shouldn't that be board's decision? Because you're talking about a hearing process, right?
Yeah, we probably don't, it probably doesn't mention report anywhere else.
Yeah, it doesn't use that word anywhere else other than this line. And you're making a decision, and the lawyer in me says, let's call it a
A
decision.
decision.
So in the first line and also in the title, I would actually, wherever it appears.
Okay. So 214 will read board decision, and the first line will read the board shall issue its decision.
And then the last line should say the decision.
Second line.
The decision. Wherever it says report, we'll replace that with decision.
Correct.
Okay. So a question, John. Do we write the decision? Do you write the decision? Do we come up with the decision and you put it into a legal format?
Last.
Okay.
You decide.
We decide.
You decide. You tell me what to write up
put it
as
into-
your decision. You then look at it and confirm whether or not
Okay.
it says what you want and adopt it.
Okay. Thank you. 215, opportunity to present further showing of interest. So do we need a time frame? When the board or its agent finds that the petitioner or an intervener has submitted an insufficient showing of interest in the unit petitioned for, that party shall have the opportunity to submit an additional showing of interest within a reasonable amount of time or within a particular amount of time. You're thinking?
Frankly, I like a particular amount of time.
You like the particular? May I suggest that you already have a rule that says if there's no activity within 6 months, it's dismissed. So that may, as a stopgap, serve
That
your
may
interest.
guide what's reasonable.
Yeah, excuse me?
That may guide what's reasonable.
Yeah. But
Yeah.
you obviously have the right to say, if you submit an insufficient showing of interest, we're going to give you 90 days to submit a new one or something.
Does the initial, does the 6-month time period get told while so you file something, you have insufficient interest, you then have, it sounds like, up to 6 months to get enough interest. And then they resubmit it, I guess, within the 6-month period of time. Is there any, could that go beyond the 6 months? You see what I'm asking?
What I have seen is if the showing of interest is insufficient, the labor organization may go back to the drawing board and reconfigure the unit.
Okay,
They may either seek more interest from other sectors of the unit, or may narrow the focus of the bargaining unit to make it more streamlined, and then present another showing of
okay,
interest.
okay.
So, about how they go about it depends on what the circumstances are, but you have the opportunity to decide if you're going to impose a limit on that.
So wouldn't that then become a new petition? Or would that be, I'm trying to think of how we did that.
Different unit.
Well, I mean, the
Could be either way.
insufficiency of a showing of interest means there isn't a unit.
Right,
So presenting a new petition
right,
is, even if it's refiled,
mm-hmm,
you're going to handle it as a new matter
right,
and do the same investigation of the.
right. So for all practical purposes, this section may be moot.
It may be unnecessary
Okay.
because, I don't know why it's in here. I certainly haven't ever seen it myself.
Mhm.
Usually what happens is a new petition.
Right. Right. So shall we keep it as is, understanding that the reasonable amount of time is guided by our 6-month limitation? Okay. Okay, section B. Same language for an intervener.
Mhm.
Okay.
So B is fine then.
Okay.
This is,
Puzzling?
I think it's odd the way it reads because it's giving the parties a reasonable amount of time in which to file, and then it says if it fails to file within that time. What does that mean? Then the board shall dismiss the petition. If there's a deadline, it needs to be specified. Because dismissal is the ultimate sanction.
Okay, so this is different from A,
Should A and B be consistent?
it seems
Agreed.
consistent.
So then we either
I think A
specify,
and B need to be consistent.
yeah.
But wait a minute, A says, finds that the petitioner or an intervener has not submitted. There's other language for units, for other appropriate units. So I'm not even, I don't understand
May I
when
make
this
a
would even
suggestion?
happen.
Both of these could be cured by where it says within a reasonable amount of time. You could say within the time frame specified by the board.
I like it.
And deal with it on a case by
Does
case.
that work?
Yep.
Yeah, and it may be because you're dealing with an organizing process, there may be a need for more time or less time, and the board can specify it. Because the board's going to be taking action to determine there's not a sufficient showing of interest, and then, in a particular circumstance, may want to specify a 6-month period, and another maybe only 90 days. I don't know. You see
Could
what I'm
we,
saying?
could we get into trouble by not being consistent?
No, because you're deciding it based upon circumstances,
Okay.
and as long as your decision is not unreasonable or arbitrary, you have the discretion to do so.
Okay, although I'm really having difficulty conceptualizing what B would look like.
What B would look like?
Yeah. The board determines that a unit other than the unit petitioned for is appropriate. But the showing of interest is still insufficient. Why wouldn't that be covered by A? Or I guess just because the board determines that a unit other than. So that would be the crux,
If I
right?
may, Madam Chair, conceptually, I could see a situation in which a petition is filed for a wall-to-wall unit, but the showing of interest is very strong in the blue-collar staff and not in a white-collar unit. And the board may want to suggest to the labor organization that's doing the organizing that they reconstruct it into an appropriate blue-collar unit, because that seems to be where the interest is. And you're simply providing guidance to a labor organization as to how they can succeed. I mean, conceptually, I think that's what this means.
Okay.
But if you want to rule on it, it needs to make sense on how it would work mechanically and in terms of time.
Okay, but there still may be an insufficient, although stronger, showing in a portion of the unit.
Correct.
Got it.
Correct. And I've seen this happen where, you know, the organization tried to organize 4 different work groups and really only interest in 2. And they came back and filed a new petition. They didn't do it this way. The board didn't intervene on it, but they came back with a reconstructed petition.
Okay, thank you. Eligibility to vote 216.
So, I'm sorry.
Yes.
So how would B read?
So B would read, in the event that the board determines that a unit other than the unit petitioned for is appropriate, and it appears to the board or its agent that the showing of interest filed by the petitioner or an intervener is insufficient in the unit found appropriate, the board or its agent shall notify the petitioner or intervener and give such party a reasonable amount of time in which to file an additional showing. If the party fails to file a sufficient showing within the time frame specified by the board shall dismiss the petition or deny intervener status. That's helpful, John. Now I can have a picture of what this refers to, so it makes more sense. Okay, 216, eligibility to vote. Okay, so a note that I have here is okay, the language in Doña Ana adds the employee may I don't know that it's that much of a difference. May request an absentee ballot at least 10 days before the election, in which case, and this is the Doña Ana language, in which case the board, after preliminarily determining the employee's eligibility to vote, shall provide the employee with a ballot to be submitted to the election supervisor, that's their system, by mail. I'll tell you, I don't like that, though, because, go ahead, yeah, because I don't think that it's up to the board to make that preliminary determination. I think that that would come under the challenge language.
Exactly.
So that's why we have that. Okay. And it says the absentee ballot may be challenged as provided. Okay. Any other discussion on section B?
No.
Section C? Okay. 217, pre-election conference. Any discussion? To 18, notice of election. To 19, ballots and voting. I just wonder if here we want to add that a valid election requires 40% participation of eligible employees.
I think that's already specified.
It is, yeah.
Yeah, it's in 223.
Okay.
Yeah.
Okay. 220, electioneering. .221, observers. .222, challenged ballots. It's all consistent with elections, all elections. 223, tally of ballots. I have a question. Last phrase, the choice of no representation, shouldn't that receive 50% plus 1 in order for the tally to reflect that no collective bargaining representative was selected? I mean, what if there's a tie?
I don't have the statute in front of me, but
If it's a tie, then representation doesn't have 50% plus 1, which is what it needs.
that's what I would
Yeah.
believe. I think that's the way the statute reads.
No representation does not need 50% plus 1.
But representation does. Got it. Okay. Any other discussion of tally?
Nope.
224, runoff elections.
It seems straightforward.
225, certification.
Good.
226, objections. .227, amendment of certification.
Interesting.
228, unit clarification. Always fun. As distinct from 229, accretion. Any discussion? 28 or 29? 230, voluntary recognition. There is language in the UNM rule that didn't do a side-by-side, but seem to recall is consistent with the PERB rule, and that is that the board shall not certify an election under voluntary recognition if the employer objects to certification without an election. Does that still stand, John? Okay, so shall we include that language in this rule?
But it may not be. It's in your resolution.
Mm-hmm.
Yeah, I mean, how can you have voluntary recognition if the employer objects?
There can be arguments made, and then certainly there would be, and that's what we would hear. But, right.
It just seems counterintuitive.
Mm-hmm. So do you feel that there's not a need to include that language here?
No, I mean, it's belt and suspenders, I think.
This is already addressed in section 11H of your resolution.
Mm-hmm.
So, I don't know that you need to add it here, but
Yeah, just,
it certainly can't hurt either.
I wonder if A, without that language, sounds like entitlement?
what
and
section,
perhaps-
John? I'm sorry.
I'm sorry?
What section in
The
the
resolution.
resolution?
It's section 11H, and on the version I have it, it's on page 6. Top of the page. But I don't know whether yours is the same version as mine.
Well, the resolution's hopefully the same. There's only one.
So it's H, and it starts out as an alternative to
Right.
subsection A. You got that? Okay. That's basically the voluntary recognition clause.
My question is, or concern is, without that language appearing in this rule, does 2.30A sound almost like an entitlement? And if we are reflecting the resolution, then perhaps we should include that.
I have no problem adding the last sentence of the resolution
Okay.
to the rules.
Justin?
That's fine.
Okay.
Now, where would that go? Would that go as F, or would it just go somewhere else?
No, just go under 230A. We would add that as the last sentence.
Okay.
Okay. B. The rest of 230, any questions or discussion? Okay. 2.31, petition withdrawal. Two 2.32 severance petition. I think we just need to add, I don't know that there's a resolution number here, so section 10 of Santa Fe Community College resolution, et cetera.
I'm
Just
sorry,
add the,
where are you?
well, 2.32, there's a blank line.
Okay.
Comprise one of the occupational groups listed in section 10 of resolution.
I just say the SFCC resolution.
Mhm. Okay, are we ready to move on to Section 3, Prohibited Practices Proceedings?
Yes.
Okay. Commencement of case. I didn't track all the sections that are referenced in B. I think we can assume accuracy. Probably not a good idea to assume. John, are you okay with the sections in 3.1B?
Yeah, I was just looking at them.
Okay.
Basically, they are charges that the employer refused to comply with the resolution, the board's regulations, the Public Employee Bargaining Act, and refused to bargain in good faith. The employee prohibited practices are 17A 4 and 5, and that's refused to bargain in good faith or refused to comply with a collective bargaining agreement. So there's a presumption that those charges would be presumed to be correct and not dismissed through a sort of screening process.
In other words, this board does not get to reinterpret the collective bargaining agreement.
It would allow charges of bad faith bargaining or noncompliance with the agreement as sufficient to proceed.
Okay. Okay. Section 3.2, limitations. We had discussion earlier about the 6-month period. Section 3.3, filing of answer. Fall default determination. Five screening investigation. Six notice of hearing. Seven pre-hearing settlement efforts. Eight prohibited practices hearings. Here is another interesting take on that section by Doña Ana, which states, "The hearings shall be conducted in an orderly and informal manner without adherence to the technical rules of evidence. The board's hearings and decisions shall be on the record. The board shall have the authority to administer oaths, subpoena witnesses, and compel the production of documents as it deems necessary to the conduct of its proceedings, and its subpoenas shall be enforceable in district court."
It all seems redundant to other sections of the rules.
Section A of these rules is basically that practice, that procedure. So I think you've already said it.
Except that our rules say the board shall conduct a formal hearing rather than informal.
Right, but the rules of evidence have already been.
Right?
You know, so.
So,
Formal versus informal administrative hearing is still a hearing.
okay,
I don't think there's any, because it says informal, you're still calling witnesses, you're still taking evidence, you're still ruling on admissibility of evidence and dispute. So I think that the formal versus informal designation doesn't really matter.
okay,
And I think you've covered all of those things in Section A of these rules.
okay. Okay,
Not that I'm supposed to be advocating. I want to streamline your rules.
advising, yes, thank you. Well, I guess my interest is in making sure that no party is going to gig us because, those of us who are on this board who are non-attorneys don't follow a particular formality. Okay,
Hopefully, if I'm your counsel, I'll protect you.
okay, briefs,
Madam Chair,
yes,
since we added that you may require briefs in other contexts, I would say the filing of post-hearing briefs may be required or shall be permitted by the board.
thank you. 310, board decisions.
Board decisions.
We'll change that language in the title and the sentence. 311, relief from prohibited practices default determination. Three 12, administrative agency deferral. And finally, 313, arbitration deferral, which looks a little different in the UNM language. Which I think doesn't matter because this sounds clear to me. This sounds clear, and I don't know that there's anything else that we need to add to it, John?
No, I think this is sufficient.
The UNM language contains sections regarding the arbitrator's award, which doesn't seem to really do anything except put things on hold for a longer period of time. So I don't know that we need to add anything here regarding arbitrator's award.
So we're good
Okay.
as is?
Yeah,
I think so,
I
Justin.
think so.
Okay.
Well, now what?
Do we need to see the rules with the changes that we made, or can we adopt the rules with the changes noted? What do we do now?
I would recommend that you postpone adoption until we incorporate these changes into the rules and all three of you get a chance to see the changes. So it's fairly simple to do a track changes revision that shows you the original plus whatever is added or deleted and gives you the opportunity to say, that's fine, or you may want to even tweak it a little bit, but adopt it at the next meetings, because before you take action, you should know exactly what you're doing. My advice.
You good with that?
I am. Who makes the changes?
Oh, weren't you taking notes? Just
I got them all in my head, but
I'm not sure I wrote them down as carefully as you might have, Ms. Schweier.
I think I have them, Donna. Were you also noting the changes as we were going through them?
In my minutes, I am noting the changes. I have my little personal recorder that I can listen to if I have a question, so I can do a pass of making the changes with the track changes showing, and then send it to the board, and you can look at it and see if there anything that's
Okay.
missing.
that would be perfect. Thank you.
Okay,
Fantastic.
so
Sure.
we are permitted to do that before we meet again,
I
right?
don't know, is that okay?
Yes, you are,
Okay,
absolutely.
okay.
Yeah, you have publicly discussed these changes, and mechanically, how they actually get incorporated into the rules is up to you, but then you would come back at the next meeting and adopt them as a
Okay.
formal action on your rules and regulations.
And this the last blank would be the date that we formally adopt them
Correct.
at the
Right.
next meeting. Okay.
Okay,
So then, would it be appropriate to set the next meeting date now?
Up to you.
I think that would be an excellent idea.
I mean, I think we have to be considerate of Donna's work, and
Right. The next governing board meeting is September the 27th. The governing board meets on the fourth Wednesday of every month. So, if you guys could schedule something after that, that would be great. And I have to notice a meeting in the newspaper, and that's got to be 10 days before the meeting itself, so,
There are certain people you try to accommodate, and the executive assistant should be one of those.
absolutely.
thanks.
So if we were to schedule on a Thursday morning, a month from now, October 12th, would that make sense to everybody?
That date works for me.
That should be fine, yeah.
All three of us in the same place at the same time?
That's amazing.
Okay.
Other than the adoption of the rules, do we have anything else for that agenda?
You have the decision about the officers, and then you also have Todd Lovato coming to discuss how you want the page set up on the website and what information to include.
Okay.
And my apologies, it doesn't work for me. I'm so sorry.
No, that's okay.
It would be wonderful to have a meeting on the 12th of the month. However,
What about the Thursday before that, October 5th? Does that give you enough time, Donna?
I think so. I think that would give me enough time.
I'm sorry, Thursday mornings are not going to work for me at all.
Okay.
I could
Today's
do
Today's
Wednesday, I
Tuesday.
could do Tuesday. Yeah, I had something misplaced in my calendar, I'm so sorry. I could do Tuesday, the 3rd, the 10th, Wednesday, the 4th or 11th.
About Tuesday, the 10th. Does that work for everyone?
That would work for me. Pardon me.
I don't know whether Monday is a holiday, but it'd be the day after a holiday. I think the 9th is,
Monday's Columbus Day, yeah.
college doesn't observe Columbus Day, it's not closed for Columbus Day, so.
So the 10th, 9 o'clock?
Board members, if I may, the executive team for the college meets on Tuesday mornings.
Oh,
Is it
that's,
possible to move it maybe to the afternoon or later in the morning? That way we have the individuals you need at the board to.
Yeah.
that's a good point.
Good point.
Tuesday afternoon or Wednesday morning?
Tuesday afternoon would be fine. Does that work for everyone?
Yeah, works for me. What time? 1:30?
Say 1 o'clock on Tuesday the 10th?
Works for me.
Okay. Tuesday, the 10th, 1 PM.
Do we want to make it 1 to 4 so we have a sufficient amount of time? I don't know that we'll need that much time.
Well, let's
Okay.
do that. And if we, I assume, John, there's no rule that says that if we conclude our business before the posted agenda time, we can still adjourn? Of course. Right? That's what I thought.
We have to stay here and fix something, right?
Right.
1 o'clock?
Yes, sir.
Okay. Okay, do we have any further business?
No, I don't
I
think.
don't believe so.
So shall I make a motion that we adjourn?
Motion to adjourn?
Second?
Second.
All in favor?
Aye.
Aye.
Aye, aye, aye.
Thank you all.
Thank you.
And the place for the meeting will be determined.
Yes, probably it will be here, but let me just make sure that it's open on that day. And if it won't be in here, it will probably be in the president's conference room. So,
TBD.
TBD, yeah, TBD.
And Donna, that gives you enough time to
Yes.
make the changes and get it to us, and hopefully we'll send it back and forth, get it in final format, and have something to vote on. Cool, next time. Till next
See you
time.
then. Justin?
Nice meeting you guys. Thanks very much. Thanks for being so
A
prepared.
pleasure.
Couldn't have done it without you.
Yes, sir.
Nice meeting you, sir. I'll see you soon. I won't.
Great to see you again. Good to see you again, dear.
Good to see
Can I give you
you.
a hug?
Family doing well?
Doing great.
Good.
Just came back from 2 weeks vacation, and back east to see you. Well, we were in southern Vermont, southern New Hampshire, the Adirondacks in New York, Boston, went to Fenway Park. My wife's family's from Charlestown, which is right on the Connecticut River, about 30 miles north of the Massachusetts
We
border.
had friends years ago in Brattleboro.
Yeah, yeah.
And actually, we lived in Stratham,
Uh-huh.
next to Exeter for a few years.
Right.
It was
Yeah,
very nice.
We stayed in Springfield, Vermont, in a hotel that had been owned by an inventor, former governor of Vermont, around the turn of the last century. Classic old
Yeah.
place, but, you know, anyway.
Not our wedding night, but the next night, first night on our honeymoon, we spent in Brattleboro,
Oh, good.
and on our way to the coast.
Yeah, yeah.
That was great.
It's nice
Beautiful
back there.
area.
We had a really nice time. Of course, I also got to go to Fenway Park for the Red
Oh, yeah.
Sox. So
Can't beat that.
got to do it. I've been
Excellent.
going there since I was 7.
Oh, wow.
So, yeah.
See you
Great
there.
to see you both.
We will.
Donna,
Thanks,
thank you so
John.
much.
You're welcome.
I appreciate your help.
Thank you.
You're a critical part of the process. as
Thank
know.
you,
I
thanks.
think more indispensable than any one of us. Donna, thank you so much.
Thanks, Vince. Thanks, Marlene.
See you again,
Thank
Donna.
you. Just be aware that it's still recording, so. Thank you.